a great pleasure and joy to welcome you in person in a meeting room in the European Parliament and to discuss what I believe is one of the most important pieces of legislation to protect media freedom, journalists, activists, human rights defenders in the European Parliament. So I'm really happy to see so many interested visitors today. We also have a live stream, so feel happy to share it on Twitter. Welcome everyone in the room and welcome everyone in the live stream. I want to welcome my colleagues from the S&D group who are joining us today. We have Cyrus, welcome, good that you are with us. We have Lara Wolters, great that you're here. And we have Maria Manuel, thanks for joining us. So we have a broad audience today, lawmakers, we have civil society defenders, academia, business, we will have trade unions with us. And I hope that we will today discuss in detail the proposal by the European Commission, how to prevent SLAP lawsuits. It's a pressing issue. To be honest, I'm a lawyer. I'm a member of the European Parliament for almost 5 years now. And I wasn't aware before I started working on this that SLAPs are such a threat in almost every country in the European Union. So we really have to do something. The aim of our event is to prepare our upcoming legislative work in the European Parliament in the Legal Affairs Committee on the SLAP Directive. And I'm very much looking forward to a helpful discussion. Please be honest with us. We are here as lawmakers to gather input how we can further improve the great proposal by the European Commission. Let us know what you think is missing, where you think we maybe overshoot the goal already. I hope that some representatives from the member states are joining us online or in the room so they can also hear what we in the Parliament, what you as affected people are thinking about this piece of legislation. Before I pass over to Chris, I need to thank three person who really worked hard to make this event happen, and that's why I think it's necessary to give them a round of applause. It's Andrea from our secretariat, it's Ines next to me, and it's my assistant Sarah who prepared this meeting. Andrea is just entering now. I was just saying thank you for the organization, so that's very important to me. Thanks for your work, and now I'm handing over to Chris. Thanks for moderating our today's event.
Well, welcome. Let's give them a hand. Welcome, everyone. My name is Chris Burns. I've been a journalist for a long time, for Associated Press, for CNN, for Bloomberg TV, and now I do reporting for Euronews. And it is disturbing what is going on as far as governments, entities, businesses, and others going after journalists, going after civil society, academics, threatening them legally. I've been threatened physically, of course, as a journalist being in different conflict zones, but this is also an issue that is involving a lot of people. And this SLAP is strategic lawsuits against public participation, SLAP. And this anti-SLAP directive, it's not working?
Huh. Okay, so let's change seats. I think this one works.
All right. You still heard me, though, right? Okay.
You're flexible.
Let's try that again. Yeah. I get the gavel. This is great. Okay, cool. Wonderful. Thank you. So, hopefully you've heard a lot of this already, but I've been a journalist for a long time for AP, Associated Press, CNN, Bloomberg TV, and now Euronews. And yes, we journalists do face threats, either physical or through legal avenues. In fact, I mean, just a few years ago, I was editing for a news outlet here where we did some investigative reporting about an airline in the Middle East that was discriminating against women. And we got a threatening letter from their lawyers saying, shut up, cease and desist, cease and desist. This happens all the time. It's a global trend. UN's Special Rapporteur on the situation of human rights defenders, Mary Lawler, says it's become a global trend. And that this EU directive, according to Civil Liberties Union for Europe, says this could be a game changer, but there are limits to it. This is a work in progress. This is what we're going to be talking about, and this is a sounding board over these next 2 hours among you, among all of you who are connected, and among all the speakers, and that's what we want to hear from you. Before we get to our speakers, we want to listen to 2 videos, and in the meantime, keep in mind your tech tips, questions via the chat in what you're watching, or you can just raise your hand over here, and hashtag anti-slap, hashtag anti-slap. If you hear something or would like to say something and cast it wider, let's make sure the rest of the world hears this. Let's move quickly to these 2 video messages. The opening remarks by MEP Iban Garcia del Blanco, S&D JURI Coordinator, that's Legal Affairs Committee, and followed by Vera Jourova, Vice President of the European Commission for Values and Transparency. So let's hear those 2 videos now.
Muchas personas con gran poder o
Often, powerful individuals or large companies with abundant resources will use these means in litigation and through ongoing lawsuits try to discourage the action of human rights defenders, defenders of public causes, and journalists who speak out against irregularities or illegal activity. And defendants cannot sustain this type of actions on a one-to-one basis, even when these causes may be obvious. Lawsuits can become never-ending and untenable for the citizens through appeals and the sheer amount of money that this costs. And this strategy is nothing new, but in the EU we're seeing an increasing use of this type of lawsuit, and we cannot allow the responsible participation of citizens as defenders of collective and public rights, the rights of all, to be dismantled in any way. And in this sense, the Socialists and Democrats in the European Parliament have initiated action to regulate this issue. Firstly, we're in favour of the creation of a European public fund made available to organisations or individuals involved in David versus Goliath struggles. And secondly, we ask that, in the most obvious cases, Member States' legislation be adapted so that lawsuits are not protracted.
ahora
And discussions on this issue are set to begin in the Legal Affairs Committee and within the European Parliament as a whole. And as I've already pointed out, this is a matter of special importance for the S&D group because at the end of the day, this is about the responsible exercise of defence of our citizens. I hope you have a great seminar, and I hope that the conclusions today will help us to work better and more effectively in future on this topic. Thank you.
Okay, the next video by Vera Jourova, coming up.
Good afternoon to all, and thank you for the opportunity to speak today about the Commission's recent Anti-Slop Initiative. Abusive litigation against those whose job it is to inform us or to defend our rights is a phenomenon that is gaining ground in Europe. Powerful persons and corporations are launching such lawsuits to intimidate journalists and rights defenders and to discourage them from speaking up, from informing us, or from defending our rights. Acknowledging that existing safeguards and national efforts are not sufficient to curb this growing phenomenon, the Commission decided it was time to take determined action at EU level. At the end of April, we adopted a package of legislative and non-legislative measures against Slups. Allow me to say a few words about the 2 parts of the package. The legislative measures we proposed consist of targeted procedural safeguards against Slups. The safeguards will apply to civil law proceedings with cross-border implications. In a nutshell, these safeguards will work in 3 ways. 1. They will enable courts to speedily dismiss claims which are manifestly unfounded. This is the cornerstone of the proposal and will make abusive litigation less attractive. 2. They will enable courts to swiftly identify elements indicating that a case is abusive and order a series of remedies to the benefit of the slop targets. And 3, they will deter such practices by allowing courts to impose dissuasive penalties on an abusive claimant. The proposed directive also includes protection for EU journalists and rights defenders from Slups launched against them in third countries. With this directive, we have taken a historic step. It is the first time that the Commission proposed legislation to protect media freedom and public participation. I hope that we can count on broad support in both the Council and the European Parliament. We need these rules to be in place soon. I therefore commend the leadership of the S&D to debate the matters in detail. Together with the directive, we also adopted a recommendation to Member States. And the two are complementary. In the directive, we cover the cross-border cases in line with our legal basis and our competence. In the recommendation, we encourage Member States to align their procedural rules to cover also domestic cases. We also want to ensure that decisive action is taken by Member States to address some of the root causes of SLAP, which are in their competence, not in ours at the EU level. We ask Member States to ensure that their defamation laws are clear and prevent misuse or abuse. In some, but not all Member States, defamation is still a criminal offence that carries a prison sentence. We would like to see such sentences abolished from their legislation. Other measures in the recommendation are meant to help build awareness and expertise on SLAP, ensure that the victims can count on support, and help collect better and more reliable data about SLAP cases. To conclude, a key feature of many SLAPs is the imbalance of power and financial resources between parties. Those bringing these lawsuits are wealthy and powerful, the targets usually not so. The fight is an unequal one. This amplifies the chilling effect of such lawsuits. It is not uncommon to target journalists and human rights defenders with multiple lawsuits at once in several different jurisdictions. Whatever the tactics, the aim of SLAPs is to harass, consume the resources and drain the morale of their targets. All this in order to restrict, prevent or punish them for speaking up to inform the public. It is a David and Goliath fight. Yet, in democracy, the role of journalists and those that keep power in check is absolutely critical. The package that we proposed will ensure that they can exercise this role. And this is not the last thing we do to protect the media and journalists. Later this year, we will propose the Media Freedom Act to further protect the independence of the media and media pluralism. Thank you for your attention, and I wish you a successful workshop today.
So our thanks to the Commissioner for that. Is this really a game changer? Does it go far enough? That's what we want to talk about today. Let me present our speakers, first of all. I'll go as quickly as I can. Pia Lindholm, Deputy Head of the Civil Justice Unit at DG Justice, European Commission. You work on anti-SLAP cases, Finnish lawyer. let me go then to Vanja Juric, Croatian lawyer, former legal advisor. You were with the International Criminal Tribunal for former Yugoslavia. I saw that. That's very interesting. And let me go over here to Matthew Caruana Galizia. That might ring a bell to some of you. He's an investigative journalist and director of the Daphne Caruana Galizia Foundation in Malta. His mother was an investigative journalist who was killed in a car bomb as she was investigating. And before that, you developed technology for the ICIJ, the International Consortium for Journalists, that led to the Panama and Paradise Papers. Very interesting. And then to Bea Bodrogi, human rights lawyer, Hungary, at the far end over here. You're defending 3 independent media outlets, Telex, Direct 36 Investigative Journalism Center, and Radio Free Europe. And so you're all in the struggle there, trying to defend those who are trying to get the truth out. Let's begin, though, with Pia. Because over at the Commission, we heard from Vera already. Maybe you can fill us in a little bit more about maybe the deterrent effect that this can have by this directive, right?
Thank you, Chris, and good afternoon to everyone. And I'm very happy to be here. Thank you to S&D for the invitation, and also many thanks to Timo Welcome. And I would also like to mention Timo's key role as co-rapporteur of European Parliament's 2021 own initiative report together with Roberta Metsola. That was one of the key starting points in the work. From the Commission side, you already heard Vice President Vera Jourova's welcoming words, but I would also like to mention her key role from the Commission side, because she was the one constantly pushing for this initiative in the Commission, and it's very much thanks to her that we are here today and we have the SLAP initiative. Why now? Why is it important to act now against SLAP? It is to defend democracy, rule of law, freedom of expression, and public debate in the European Union. There is need to act now to prevent the SLAP from growing roots in the European Union, and the need to have an effective deterrent effect. This is what is about to cut the growth of SLAP in European Union. Vera Jourova already mentioned that this is an initiative which consists of 2 key components. We have a package of a legislative and non-legislative component. The legislative is the proposed Anti-Slop Directive, and then there is a Commission recommendation. I would like to stress, although this event is about the legislative initiative where the Council and the European Parliament have a key role in the legislative process, that this is indeed a package, and the recommendation is an important component of anti-SLAP action. So the directive alone, once it has been adopted and transposed by the member states, that is not enough. We still need to have the components brought by the recommendation. There are certain limitations to set for the legislative proposal because of the legal basis. So to have the comprehensive effect, we need also the recommendation. Vera Jourova already mentioned that the proposed directive is a targeted instrument consisting of procedural safeguards against SLAP in a cross-border civil proceedings. So these are setting some of the limitations of the legislative proposal. The recommendation, however, is horizontal, and it applies to all kinds of proceedings, civil, criminal, and administrative, and also not only cross-border, but also domestic cases. And one of the key good points is that its implementation has already started because it's a Commission recommendation, so it is directly applicable, and all the work on the supportive actions have already started. I want to mention just a few highlights concerning the proposed directive, so I'm not going to present the proposal. There is no time for that, and I'm here today more to listen to your feedback and what are your views than giving our views on the proposal. Anyway, the Council negotiations have already started. We are very happy about that. They were swiftly started by the French presidency. However, these are still very early days in the negotiations. We have so far only had 2 meetings. Maybe just to mention that the proposal sets out minimum standards, so member states are welcome to go beyond the protection proposed in the directive and provide even better protection than what is foreseen in the proposal. There is also a strong role for national courts and judges, and the aim is really to provide a toolbox for national judges which they can use when they encounter a SLAP situation. And indeed, again, to stress that the aim is to act as a deterrent so that the SLAPs are not filed in the first place. The key components of the proposal are, Vice President Jourova already mentioned these, it's early dismissal in case of manifestly unfounded cases. Then there are remedies against abusive court proceedings. These are award of costs, compensation of damages, and a penalty. There is also an option for the court to require a security from the claimant to cover costs, and this can already be required early on in the proceedings, so in the beginning of the proceedings. I would also like to highlight the wide personal scope of the proposal, so it would apply to any natural or legal person who is targeted with SLAP on account of his or her engagement in public participation. There is a narrative which focuses on journalists and human rights defenders, but the aim is actually to protect widely all those engaged in public participation and targeted because of that, meaning also academics, trade union activists, and other groups. Key challenges ahead. For the legislative part, one of the big challenges will be to find the right balance of fundamental rights between freedom of speech and freedom of expression on one hand, and access to justice on the other hand. However, here I think it's important to remember that SLAPs are not initiated to gain access to justice. They are initiated to harass, to intimidate, and ultimately to silence the defendant. Second big challenge is to make these safeguards successfully to work in member states' national law, because national laws have differences, and we need to adapt the safeguards so that they work for all member states, and at the same time making them work, making them efficient. Also to note, maybe that is of interest, that some member states are actually at the national level looking into SLAPs, so there are some national legislative initiatives which go very much to the same direction as our proposal. And for the non-legislative part, the aim is to ensure efficient implementation already now, to raise awareness, to provide support to targets of SLAPs, and to start monitoring the phenomenon in the European Union. And this is all from my side. We are very interested to hear your feedback, and we are also very much looking forward to working together with the Member States and the European Parliament to take efficient action against SLAPs in the European Union. Thank you.
Pia, thank you very much. Let's move on to Matthew. Matthew Caruana Galizia. Matthew, you've been involved in making this what's called a case report. Let's try to make this case for why we need to do this and how prevalent that the threat of SLAPs is. You're in the Coalition Against SLAPs in Europe, that's CASE case, which involves not just journalists, but civil society, academics, and others, right? It's widespread what's going on.
Yes, it really is, but it wasn't like that at the beginning at all. I first started working on SLAPs towards the end of 2017, when my family inherited 43 defamation cases that had been filed against my mother. It was a huge shock because they had all built up gradually over a few years. But then when we were faced with the fact with dealing with this huge number of cases all at once, we started to question how it was at all possible for most of these cases to be filed, let alone for them to be inherited. At the beginning, it was a very lonely fight. Very few people knew what SLAPs were. We looked to the US and what protections had been put in place in different states in the US, and we started to ask why we don't have these same protections in Europe. Within the European Union, which is supposed to provide a legal framework that's a bastion for free speech protections. And we slowly started to engage in advocacy with politicians. We're very grateful for the MEPs that took up that torch quite early on. But things really started to accelerate when we began working with organizations that were focused on climate justice or climate campaigning, environmental campaigning, that had dealt with defamation lawsuits like journalists for many, many years. And we really found there was a huge strength in press freedom organizations joining forces with these more activist organizations working on climate justice and things like that, as well as tax justice and so on. So things really started to accelerate at that point when we formed this organization, the Coalition Against SLAPs in Europe, and we started to build on research that had already been done by the legal research unit at the University of Amsterdam, cataloging SLAP cases from around Europe that journalists, activists, academics had faced. And we started to see certain patterns, including the one, for example, where there was a huge imbalance of power, a disparity in power between the defendant and the claimant, or where the SLAP threats led to actions or journalistic pieces being silently withdrawn from the public sphere. So we described these worrying trends in the Case Coalition report, which I think had quite a significant impact. It's been cited by the UK Ministry of Justice in Parliament in the UK. And it really paints a picture of an increase in the threat around Europe, where we see year on year that the tool is being used more and more to defeat the campaigns of activists, the campaigns of politicians, the work done by academics, that is scientific work, the investigative work of journalists, and so on. I think none of us ever imagined that we would have a draft directive in a relatively short amount of time, and I think we really have to thank Pia for all the work that she has done in that regard, because I really can't stress enough how desperate the situation was 5 years ago, and that we've come a really long way since then, relatively. Everyone was telling us, you're wrong to use this word, SLAPs, no one is going to know what we're talking about, but I think we succeeded in making it a kind of keyword across the European Union. Now when we have meetings with officials, everyone tends to know what we're talking about. Hopefully, member states will adopt the directive. I mean, we're shifting gears a little bit now, engaging more with as Pia said, I mean, we need to listen to the feedback, but I think the first step has to be adoption of the directive. Once that step has been taken, then us as a coalition of non-governmental organizations will begin working with member states to ensure that also what's in the recommendations is implemented. For us, it's really a package of things that go together. Judges need training, even journalists need training, prosecutors need training. There has to be legal support for journalists that do this kind of investigative work, for activists, for academics, anyone who is speaking up on matters that are in the public interest. We are not attempting to create a privileged class of people, journalists, activists. We're not attempting to privilege anyone that fits into sort of those vocational brackets. It's really anyone who is speaking up in the public interest, anyone who is performing any kind of service that complements the work of investigative journalists or activists.
Well, thank you, Matthew. I want to come back to that. But I might remind all of you listening that you can get the translation of this if you can dial into either German, English, French, or Spanish. There are different interpreters. Here behind the glass, you can see them hard at work, and they will help you to perhaps better understand what we're saying here. Let me move to Bea Bodrogi. And Bea, I guess you do see the merits in all of this, but there are limits. Maybe we should talk about that. Matthew did mention that as well. It's mainly cross-border. That's when I read the directive. I thought, okay, cross-border, but what about national?
Yep. Yeah, thank you. First of all, thank you for the invitation. I'm really honored to be here. And I will turn to your question, definitely. This is, I'm not saying that always, but quite often the role to criticize draft laws. But let me start with a personal comment. I feel really honored to be part of the expert group that developed this directive together with other experts. We came from different fields and we thoroughly discussed the directive and the recommendation. And this is special to me because in the last 12 years, as an ex-legal expert of NGOs, I didn't have a chance to take part in any public or real public legal consultation on draft laws in Hungary. Actually, it's impossible in Hungary to be part or to take part in draft laws consultation if you are from the civil society sector. So I just wanted to share this personal experience and comment. And before going to talk about the limits, let me say a few words, welcoming words on the initiative, especially highlighting the holistic approach of the initiative, which covers legal and non-legal measures. For the rules and recommendations to bring real progress, I think a profound cultural change is needed. This includes lawyers, judges, public authorities across EU. New laws and practices are a good start, but I think we all know that without a mindset shift, there will be no real change. Therefore, the combination of legislative and non-legislative measures proposed by the Commission seems to be the most effective ways to address SLAP. And as has been already mentioned, it includes awareness raising, training, support mechanism, providing legal aid for SLAP victims, reporting and monitoring. And I'm really glad that all these measures are included in the initiative. Why the non-legislative measures of the initiative are also important? Because the legislative measures have limitations, and let me talk about in few points about this. First, the proposed the directive only covers SLAPs in civil matters with cross-border implications. According to research, most SLAP cases are taken in national level. So I think, and I know, of course, that the recommendation at the very first point contains that countries are recommended to apply these measures in domestic cases. But I have serious concerns with my country and maybe with some other countries in EU that the recommendations or the directive will be not followed. Second, the proposed law also includes an exception to its broad scope for cases related to administrative matters. This means to me, at least in Hungary, that these exceptions will mostly cover GDPR-related cases. The use of data protection law, which allows claimants to sue over any inaccuracies in personal information, even if the information is not defamatory, is on the rise in a number of countries, including Bulgaria, Hungary, Malta, and the UK as well. This was the recent case in Hungary where one of the richest industrial families in the country has been able to use data protection laws to stop reporting on aspects of its business activities.
Can I just interject here?
Yep.
Does this mean that GDPR should be amended because of that? That maybe some people are able to hide behind that or use it as a vehicle? Go ahead and put.
I think one of the problems is the application of the GDPR and the right balance between personal data and between the right to privacy, data protection, and right to freedom of expression. And I'm not sure that the GDPR should be amended, but I'm sure that judges and who apply the laws should be informed about ECHR case law and about those tests which is applied or which are applied when balancing between two fundamental rights. So therefore, the judicial training is extremely important, at least in those countries where GDPR-related SLAP cases are of real concern. And I could see in the recommendation that this is included. So the Commission heard our complaints that we kept saying, few of us, that GDPR-related cases can be considered as SLAP cases as well. And let me just share one case from my practice in which I spent roughly 60 or 80 hours in the last few months, which regards 3 legal procedures against Telex, which is one of the biggest independent online news portal in Hungary, and I work for them as well as a lawyer. And there was a statement in an article saying that a company spent or operates from public money as well. This company is called Megaphone, and this company spent roughly 1 billion Hungarian forint on Facebook advertisements.
Which is about what? How much is that in euros roughly?
I cannot calculate now,
okay.
But it's a lot of money. The advertisements were spent on spreading government messages, and we are talking about the election period. And this article revealed that, and also concluded that this company spends public money. And 3 civil procedures were initiated, and the owner, or the journalist, was also harassed online. And we won this case. I spent really a lot together with the journalist because she had to appear before the court. She had to give testimonies. And finally, we won in all cases. No appeal was made. Is it a SLAP case? I think yes. For one sentence, litigating for one sentence, 3 civil procedures, saying that this was a false statement. We could prove in the court that this wasn't a false statement. And at the same time, the journalist was online harassed. I think this is a clear SLAP case. But the rest of my time working for Telex, I spent on writing GDPR-related submissions. So why I'm upset and why I'm criticizing this type of limits of this directive, because it seems that these cases will not be covered by the directive. Of course, I'm aware that the recommendation might count if Hungary would follow the recommendations. But what also matters, just to closing my presentation, I don't want to take more time, why I really highlighted the holistic approach is that that judges really have to be trained and really have to know more about this phenomenon. And I'm sure that this is one of the key points, at least in terms of Hungary. And the other very strong element is providing support for victims. This might be, if SLAP victims will be funded for covering the legal representation, that would be a great help to them. So I stop here. I think we can continue from here.
Okay,
later on.
Bea, thank you very much. Points well taken. We're feverishly writing notes on this. That's good. Let's move on to Vanja Juric. How could this directive help you in what you're doing in Croatia?
I would actually also like to thank anyone who has invited me here today. I'm very honored with this and also with being a part of the expert group for SLAPs. I'm a Croatian lawyer, so a Croatian media lawyer, and I'm not sure if you know, but Croatia is one of the champions in the European Union regarding SLAP lawsuits. I'm representing one of the biggest news online portal, Index HR, as well as the Croatian Journalists Association, so I'm very familiar with the problem. I think this,
So a champion in the sense that it has the most cases.
in a bad way, not in a good way. Yes.
You had, I think you numbered 250, is that right?
I have 250 cases so far. Not all of them were SLAP cases, but a lot of media law cases. We have a lot of lawsuits. Basically, it's damages claims. So, yes, I think this proposal is a really good first step in the process of protection of public participation and freedom of expression, which really are fundamental for any democratic society. I'm sure it wasn't an easy task to draft it. As Pia said, we have concurring rights that need to be well balanced. And in each situation where we have to balance between two rights, it is really necessary, as Bea said, that we have educated judges and educated practitioners. I'm saying this because I want to also underline the key importance of the recommendation. Even though it is not obligatory for the member states, I am really hopeful that the member states will realize that this piece of legislation cannot go without the recommendation, cannot go without education of judges and raising awareness, and those are really necessary tools that need to go hand in hand with the legal solutions. The thing is, I'm not sure if I'm stressing this too much, but you can have a perfect piece of legislation if at the same time you don't have people who know how to apply it and interpret it, then we still have the problem and nothing will change. So I'm saying this from Croatian experience, where we have laws that are fine. I mean, they can always be better, but our laws are fine. But we have big problems with application and interpretation of the laws. So when it comes to proposal, I think it has many good solutions. I'm not going to go through all of them because Pia and others already said enough. I think broad definitions of public participation and public interest are really good. I think a right of NGOs to intervene in the proceedings is really good and positive and will give a lot of security to the defendants. I think costs, damages, penalties to abusive claimants are also very good. The central part, though, is the early dismissal for unfounded claims. It's really important, but I am afraid of the interpretation of the term manifestly unfounded.
I think because it's kind of ambiguous. Is that the problem?
Yes, and it's a very narrow term which can be very narrowly interpreted. And I'm speaking from Croatian experience. I'm actually expecting that none of the lawsuits in Croatia are going to be regarded as manifestly unfounded. So that is one of the reasons. And also the application for dismissal for manifestly unfounded claims only applies to manifestly unfounded claims, not to all others abusive claims that are usually also unfounded, but not manifestly unfounded, but just a little bit unfounded. So, yeah. Also, when it comes to forum shopping, I think it's a great solution. It poses a big burden. I think Matthew may have personal experience when it comes to that. I think here, as it seems, it is under some other pieces of EU legislation still possible for forum shopping to happen. So I think we really have to keep it in mind and keep in mind that EU legislation has to be uniform when it comes to prevention of forum shopping.
But for forum shopping, you mean it's also the term libel tourism, is that right?
Yes,
that people can
right.
go. Put your mic on.
Oh, that's right. People, claimants, abusive claimants, are choosing countries to bring charges where it is most expensive and it causes most harm to the defendants. So that is why it's really necessary for all of us to do anything possible to stop it. When it comes to limitations, Bea and Pia were already saying something about that. I will try to keep it short. So it only regards civil and commercial matters. I completely understand the legal reasoning for the proposal to do so and the limitations of the EU legal system. But I think we can all agree that many other sorts of procedures also have significant SLAP elements, such as criminal charges for defamation, misdemeanor charges in Croatia, administrative claims to public authorities related to GDPR issues, as Bea has previously said. So I'm saying I understand the reasoning, but I think we also have to keep in mind that if the proposal only regards civil and commercial matters, our abusive claimants are most probably going to adapt their proceedings they're going to use. They're going to turn to different kind of proceedings that can also cause very much harm and be very, very hard for the defendants. I can speak from Croatia's perspective when it comes to criminal charges. For example, in Croatia, we still have criminal defamation. And if the defendant is found guilty, then he can almost automatically seek damages in the civil court. In that case, the civil courts will not be authorized to decide anything else except the amount of compensation or damages to be awarded to the plaintiffs. So I think we are going to go back to square one, and I think this is also an issue we have to think about. My last point is going to be the fact, also one of the limitations of the directive, is that it does not regulate purely domestic cases, which are a vast majority of all SLAP cases in Europe. I can repeat that I understand the legal reasoning for this limitation, but if the member states don't use the recommendation and insert the provision in our legislative systems, then, for example, for Croatia and for SLAP victims in Croatia, this is not going to mean much. I'm not sure if there are any SLAP cases in Croatia at this point who have cross-border implications. So this is the thing now. I am, though, very happy with the fact that there is a broad meaning to cross-border implications. Also, inserting this, for me, new term of transnational public interest, which I think is really good, and we are becoming so much more connected that transnational public interest really does exist now, so I'm very happy with that. So to sum it up, this is kind of personal, but I'm going to say it anyway because I'm very passionate about this. I read a really good quote lately which says that the culture is defined by the worst behavior tolerated. And if we speak about democratic values and democratic societies, I think that preventing public participation, restricting it, penalizing it, it really is one of the worst behaviors for any democracy. So I'm hoping we will get big support for this directive and for trying to broaden its scope as much as possible.
Vanya, thank you very much. Just 2 points. One, the 1 billion forint, I'm told, is 2.5 million euros. It's still a considerable sum, though. Right? And this libel tourism or forum shopping, some say that one stark example is in the U.S. right now between Johnny Depp and Amber Heard, because the two of them live in California, but Depp pressed the charges in Virginia, supposedly because the anti-slap laws there are not as tough. So there's an example right there. Maybe, do we have any questions, first of all, out in the audience? Would you like to pose a question? While you're thinking about this, and those of you also who are watching this virtually, send in your questions via the chat. Pia, can I ask you, you've heard the yin and the yang of this. Maybe we talk about the criticisms now. How do you address that? What are your feelings about that? I mean, you did yourself already say that more needs to be done, but from what you've heard just now, what do you think?
I would say that what Bea and Vanya said, actually, it is very fair points on limitations to our initiative. Unfortunately, it's a reality that the limitations are based on EU competencies. So we have basically done the maximum we can within our competencies.
Okay. That's an admission that, yeah, more needs to be done. Timo, you had something to say. Please.
I have questions, so some of them, but I'll not raise all because I hope there are also questions in the audience. So first of all, thanks for being here with us, for sharing your thoughts on the initiative proposed by the European Commission. We are now, well, we will hopefully soon start working on the proposal here in the European Parliament, and I think that, well, there is an approach taken by the European Commission in the proposal in Article 4 trying to define matters with cross-border implications very broadly. So saying that there is a matter with cross-border implication if the act of public participation concerning a matter of public interest against which court proceedings are initiated is relevant to more than one member state, or the claimant or associated entities have initiated concurrent or previous court proceedings against the same or associated defendants in another member state. So I can see the will of the Commission to cover more cases than ones with a clear or obvious cross-border effect. So with a claimant and a defendant in two member states. So I wonder if one of our panelists sees this as an opportunity to widen or broaden the scope of the directive to cover more cases. Obviously, we will not be able to cover all cases, unfortunately, because of the treaties, and I think it's very unlikely that we will change the treaties in the near future, but let's see. So this would be one question, one general question. Whoever has an idea on that, I would be happy to hear more about it. Pia, as you are already discussing also with the member states, and you have been done, or you did the impact assessment and all this. What is your feeling? Will member states in the end indeed go beyond the legislative part of your proposal and maybe start implementing the recommendations? Maybe you have already an idea what member states might feel. And Matthew, you mentioned, and others also mentioned it, that training and legal support is of utmost importance. What concrete examples are already in place you're aware of? So what can be done to train people on SLAP cases? Then I would, well, maybe one last question. To Vanya, it is clear that the recommendation is as important as the directive. Well, but how should the EU help to raise the awareness among the member states now that the recommendation is applicable? So it's not enforceable law, but it's there. It's meaningful. What can be done about it? Sorry for the many questions.
No, that's quite all right. Shall we begin with Pia? Or, yeah?
Well, I think the first question is actually to the other panelists, because I'm the one drafter of Article 4, so I think this is maybe to test with the other panelists whether they see room to widen the article. But then to the question Timo addressed to me, will member states go beyond and start implementing the recommendation? Certainly, a recommendation is obviously a recommendation, but certainly the recommendation is also meant to be implemented, and we will be also monitoring and working together with the member states to reach the best possible implementation. And as I said, the work has already started. And also in the transposition of the directive, when the moment comes, we think that it makes sense for the member states, also for the member states, to widen the protection to domestic cases, because it appears unfair that in the domestic cases the victim would have less protection and less safeguards than in the cross-border cases.
Yeah, that's a good point. And please send in your questions. Raise your hand if you have a question. Obviously, you're here because you're interested in this. There must be a case that comes to mind. That would that case that you're thinking about, could that be covered by this or not? And that's why I want to ask Matthew. I mean, 47 cases against your mother. If this were in effect, this directive, would it have any impact on those 47 cases, or are they all domestic and wouldn't be touched by it?
So while the directive deals mostly with cross-border cases, you can't really look at the directive as an instrument alone. I mean, sure, you can, but it's part of this sort of package of instruments that also includes the recommendation and the training that comes with the recommendation for judges and prosecutors, because there were criminal defamation cases too, although that's no longer law in Malta. So you really have to look at everything together. And I think with the deterrent effect that has been set now with the proposal of the directive, with the recommendation that is currently in force, would the majority of those cases have been actually filed? I think probably not. With the kind of awareness that has been generated, with the conversation that's taking place in places like the European Parliament, there would have probably been enough of a deterrent effect created for the majority of those cases not to have gone ahead. But this is in a country like Malta that cares about the opinions of European institutions in general. When it comes to Hungary, for example, I don't think I can say the same. So we cannot count on this 100%. You then need other more serious instruments to come into play, I think. There are governments that are sort of that I guess can be shamed into taking action, and then there are others where you need the stick.
And Bea, because you were involved in drawing this up, what do you think about that, about the scope?
Honestly, I mean, how to use it creatively? I didn't wave my hands to answer this question because no creative solution occurred to me so far. So I don't know how to use this article creatively, to use this article on domestic cases, to be honest. But just if one comment on your question on recommendations. I think since in several countries, those who are initiating SLAP cases are government or government-related companies or officials. This is not only Hungary. I think there are many other countries who have the same case. I think independent bodies should be included in carrying out recommendations like European Judicial Training Network or focal points who are independent in that country. So what I'm saying or suggesting that each country should be looked on its own, with its own problems and with its own challenges. And I think through recommendation and even with the directive, there are ways how to challenge SLAP cases.
Okay, I have questions coming in virtually. But Vanya, the question from Timo, would you like to answer that? I'm sorry, it's so far away now, I can't remember which one it was. You can help us with that.
It was about raising awareness, if I remember correctly.
Yes, that's right. Yeah.
I'm just a regular attorney at law, so I'm not sure I'm the specialist for activism, but I think the main thing we have to do, and this is what we have been doing for the last couple of years, is to constantly talk about it on the EU level, on the national level, repeat what SLAPs mean, feel the claimants ashamed for what they're doing, maximally, to the maximum extent possible, support all NGOs who are doing what they're doing regarding SLAP cases, organize workshop, talk. Basically talk. I'm not sure, I'm sure some other people know much better methods than me, but I think all we need to do is talk about it constantly.
Okay, and Matthew, you had something to add. Please.
Yes, just to answer the question from Timo about concrete examples of training that can be provided. the training works both ways. So with journalists, what I find it's really helpful to do proper training on how to make their investigations as bulletproof as possible, so that if legal action is taken, you will have a good defense. This makes everyone's lives a little easier. But of course, as you said, training does need to be provided by independent bodies. In some Balkan countries, the Council of Europe has a very effective training program called JURI that focuses on training members of the judiciary. It's run entirely by the Council of Europe as an independent body, and I think that has been really effective. It's something that needs to be done in EU member states too. Quite often members of the judiciary have quite an antiquated understanding of what journalism is, of what activism is, how academia works, and this can lead to judgments that are quite strange and unexpected and not really compatible with human rights. But of course, it should not be the case that every time this happens, we rely on the European Court of Human Rights. 10 years have to pass before you get a judgment. It should end ideally at the national level, and that can be done by providing training to the judiciary. So far, the sort of practical training that I have done is within this frameworks of JURI that's run by the Council of Europe. And that I can name as a really sort of good concrete example. It also includes training for journalists.
Okay, we have a question out here in the audience. Please, if you could give us your name.
Rémi Carton, and I'm a student at the Université Libre de Bruxelles. And one of the main tools of a SLAP suit is the fact that it's usually repeated suits. They come in block and they basically constitute legal harassment. And yet the main remedy for people victim of a SLAP suit in the directive is to apply for early dismissal. And when they do, what's proposed as the burden is for the claimant to prove that their suit is not manifestly unfounded, which is a standard which is entirely related to the actual merits of the one particular case on which the application is made. And I was wondering what consideration our intervenants should should be taken into account, so that the courts are at least incited to take into account not just the merits of every single case that is brought, but also in considering an application, the fact that these cases are not isolated but come together as a block where they try through repeated lawsuits, which on their own may be more or less founded, to actually partake in this legal harassment.
Would anyone like to comment? It's an interesting point. Anyone like to comment on that? Some of these lawsuits come in groups, right? And about the idea of early dismissal, right?
Yeah, exactly. The fact that when you apply for the dismissal, the fact that there are several lawsuits which are themselves, the fact that they're taken together as a group is what actually constitutes the SLAP dimension of the lawsuits. And yet, this fact is not taken into account, at least not in the kind of standard which is laid out here.
Are you suggesting there should be something in the directive?
Well, I'm suggesting that it is somewhat weird that whereas the directive actually recognizes that the fact that there are several lawsuits at a time is constitutive of a SLAP suit, yet this does not appear in the proposed standard for an early dismissal of the case.
Okay, Pia, please.
Just to note that in the definition of abusive court proceedings, we have actually a point which one of the indicators of abusive court proceedings is the existence of multiple proceedings. So that is already an indication of abuse. And also, I would like to note that there is also this, I already mentioned, that the court can require a security in the beginning of the proceedings. It's Article 8. So if the court identifies this type of phenomenon, that there are many proceedings, the court can impose this security for the claimant, and we consider that that is already working as a deterrent against multiple proceedings.
Okay, yes, please.
Hi. First of all, I want to thank everybody for an interesting panel. It's been a great discussion.
Can you give us your name, please? Name and title.
Oh, sorry. Luka Avramovic. I'm a study visitor at the European Parliament. So I want to go back on one of the points that was mentioned, which was that culture is defined by the worst behavior allowed in a society, which I think is a really good quote as well. And first of all, I have a question maybe to Pia and Bia. That could we see countries not implementing the recommendations get any sort of repercussions? Because at the end of the day, they are just recommendations. I maybe want to call up on the same concept that might have been used with Poland and the rule of law breaches, and we only found out today that Poland are actually getting their funding back. So are we going to have any system where we can have repercussions like that, or are they going to be dropped somewhat like they are with Poland? Maybe to all the panelists, what's the future of this legislation? Because we talk about a transition period between now and being able to enforce it more at national levels. And then to Matthew, maybe more specifically, you spoke about how your work was modeled on the US at state level, but the US legislative system is very well known to be not, what should we say? It is politicized in the sense that we have judges that are members of parties, and it has a lot of issues with David and Goliath cases. So, for example, Donziger versus Chevron, where we saw Donziger being locked up for almost 3 years in his house. How do we model the EU's perspective on something that has been, in my opinion, very much failed in the US when it deals with big oil companies or big actors and just small lawyers or journalists? Thank you.
Thank you. Shall we start with Matthew? You want to answer that last one first, please?
I mean, of course, with the model on the US, there are exceptions. So there are some things which are quite good, like the ability for judges to impose fines on the claimants if the claims are vexatious or abusive. But of course, there are some things which I don't think have a place in any European legislation. For example, the lack of a limitation on potential damages, which in some cases has led to media organizations being shut down completely. So of course, that's something which is not desirable. It's a sort of artifact of the US system that we don't want to carry into any proposals in Europe. And same perhaps for politicization of members of the judiciary. That's of course something that we would want to avoid.
Okay, the other questions? Yeah, yes,
May
please.
So I'm not a specialist on the subject. I'm member of this committee. That's why I'm interested and I'm here.
Can you give us your name and title, please?
Maria Manuel Leitão Marques. I'm a Portuguese MEP from this group, and I'm member of this committee. And of course, I'm interested in everything we discussed here. But it's clear for me, but I know the problem in general, as a citizen's interest in this matter and some cases. It's clear from this discussion that the directive proposed by the Commission will not be sufficient to tackle all the problems related to SLAPs. So we need the Member States to go further than this, for example, following the recommendation also presented by the Commission that in certain way the recommendation is more important than the directive. It's something not, I think you understand me, but the recommendation is very important in order the purpose of this directive be effective in real life. So what my question is, how can we motivate member states to follow the recommendation? What is the Commission, what is thinking to do in order to convince member states to follow this recommendation?
Which is a bit relevant to the gentleman's last question. What levers can we pull to get national governments to institute this idea of anti-SLAPP on a national level? Because that seems to be the big hole in the Swiss cheese. Pia, what levers do we have?
First of all, I would like to mention that actually the member states are, well, we are early on in the negotiations, but the member states also have will to tackle the phenomenon and are constructive. So we hope that the negotiations will go well. Also, yes, I have also tried repeatedly to refer to the non-legislative and legislative part as a package. So the recommendation is indeed very important. We have already taken first contact with the member states to start the implementation. Obviously, a recommendation has also its limitations. So the recommendation as such, it's very horizontal in nature, but it has a limitation of being a recommendation. But we will do the utmost with the recommendation. Even if it's a recommendation, we will monitor the implementation, and the recommendation also clearly states that we will hold discussions with member states and stakeholders in relevant forums to work on the measures and actions proposed in the recommendation. Also, I would like to mention that the rule of law reports already monitor SLAPPs as well, and the 2021 rule of law report already identified SLAPPs as a serious problem in some member states. So the rule of law monitoring will continue as well. I would even say that probably with more awareness of SLAPP, it will increase. So there will be enhanced monitoring concerning SLAPPs, and obviously then the consequences, if there is a rule of law issues, there will be the consequences following that one.
Just one comment that, for sure, infringement procedures will be not initiated if the recommendations are not implemented. That we know for sure. But still, I think what Pia just said, I think the rule of law reports cover the media freedom issues. So we can hope that SLAPP cases will be involved, and not only reports by the government, but also by shadow reports of non-government organizations in each country, because they work a lot on this field and they have direct contact with the victims. So I think this is also important to listen to, and to read and to get these shadow reports from different organizations.
But as we kind of discussed during lunch today, linking anti-SLAPP with the rule of law mechanism, that's a non-starter, right, Pia? Or is that a possibility?
Now I must admit my limitations. I'm not a rule of law specialist, so you're asking the wrong person here. I'm civil law lawyer. So, well, what I can say that we will certainly do our utmost in the rule of law context to enhance reporting on SLAPPs, and I've already seen that there are now kind of issues regarding member states which were not reported last year, and we are looking now more closely also on those member states.
Sorry to bother you again, but I have another question for you. In your view, what is the likelihood that the member states will go beyond the minimum requirements set by the directive?
This is actually an issue which have already come up with some member states, because in some member states you have, for instance, a very strong protection to journalists. So this is the issue that has come up, that can they maintain this high level of protection to journalists whilst there will be protection to other groups as well. And that's why I mentioned that this is these are minimum rules. So if member states want to have a higher level of protection, it's possible. So indeed, there are such cases.
We have another question here, please. And then back there, right? Okay.
Hi, good afternoon. I'm Federico Sarchiapone. I'm a trainee at the council. And
your name is?
Federico Sarchiapone. And I was wondering, in your opinion, what is the role of social media platform in the SLAP context? How they can I don't know, give early indicators of SLAPs, or also how training can also be delivered for them?
Is that something you examined when you drafted, when you worked on the directive? Okay. Maybe, or...
No, I mean, awareness-raising perspective, I can imagine that could be a good platform, but this is just the first idea that came to my mind.
Okay. Yes, Matthew.
I mean, I'm just not really sure about the question. Do you mean whether social media platforms could be considered to be publishers, or is that the question?
Yes, also, I mean, social media, it's like civic space online, so how that comes into play, is it taken into consideration in recommendation, or also in the Digital Service Act was taken into consideration as well? What's your opinion on that?
Yes, if it's like using social media for public debate, then in social media the persons can also be protected, because, as I explained, there is a wide personal scope for protection. And also to mention that actually we are also aiming to protect secondary targets. So actually internet providers can also be targeted. We actually, when we had the stakeholders consultation, the stakeholders brought up cases where the activists' internet provider was targeted with threats that they will sue the internet provider. And the aim is actually also include that in the scope of protection, because it is because of the primary targets participation in public debate that the internet provider is targeted, or social media platform. And of course, nowadays it's a very efficient way of silencing someone. If you don't have access to internet and you don't have access to social media, then you are efficiently silenced. So that's why we wanted to have this secondary protection.
Okay, let's see, was there another question over there? You still got it? Okay.
Yeah, merci. Je vais m'excuser de revenir sur le point que je soulevais tout à l'heure, et je...
Thank you. Well, I do apologize. I'm going to go back to the point that I was underscoring earlier. In the directive, the idea is to have a dissuasive approach. But there are actors that have the budget to cover these sorts of costs. I'm thinking of big companies here, of major corporations, because people making use of SLAPs do so not just because they think they might win the case. The whole point of the SLAP is to harass the people who are being targeted. The point is to wear people out and to wear their resources out. So yes, there is a safety mechanism there, but it's really about burning people out. It's about the stress, about the time that this takes.
Legal.
Chair, yes, of course, the legal costs. Speaker, yes. There's the matter of the legal cost, it's the matter of the security deposits and all of that. But really, this is also about mental load. It's about the cognitive load that people are suffering from. That's what makes these SLAPs so effective. there's no legal mechanism specifically to fight back against that. So, what victims of SLAPs want is to get to a conclusion as quickly as possible, to try and move past the unfounded claims and to get to what's really on the table there. So if you look at the legal standard on the table, quite often the only thing being dismissed is an unfounded claim. And I feel that there may be a risk here. The risk might be, if the courts don't apply a standard that will enable them to dismiss as many cases as possible, there is a risk then that the victims themselves might be dissuaded from requesting that these claims be dismissed, because that adds even more time. It's a snowball effect where it causes even more of a cognitive load. So actually this dissuasive effect might actually make things even more difficult.
Any takers? Yeah? Okay.
Actually, there I do not agree. I think we are providing quite an efficient package of measures, because there are a number of different measures, not only early dismissal, but also the procedural safeguards. Indeed, there is often also the psychological damage, but that's why in compensation of damages, we're specifically mentioning that it's possible to have compensation of both material and immaterial damages, such as physical and psychological harm. So we have also tried to take that into consideration. So it's not one deterrent measure. It's all these measures in combination, and also in combination with the supportive measures to the victims, which are provided in the recommendation. Because indeed, you are correct when you are saying that when it's a big business or somebody with lots of resources, they don't, and that is part of the SLAP phenomenon, that often claimants are in this type of powerful position that they can file multiple claims because the cost is not an issue for them, even if they don't even expect to win the case. But we do consider that with this package, it will be an efficient signal to them that it's not acceptable, it's not successful, and it will not work.
Bea, you had something to add?
Yeah, just to add what has been also said, that penalty can be also issued according to the proposal. Penalty can be issued by the court, and I think in this regard, I would highlight, which is not in the article, so this is a good place to say or comment on the article, that the financial situation of the claimant should be taken into account when issuing a penalty or a fine, because that's what matters. That could be a real deterrent factor, and as far as I remember, there is no such comment in the article.
As a practical example, in Malta, I mean, there's a limitation from publication of about a year within which you can file a libel claim. But currently, even if someone files a defamation lawsuit for an article that was published 10 years ago, the case will eventually be dismissed, but it will take years. And it's upon the defense, the obligation is upon the defense to prove that it was actually published such a long time ago. And even when the case is dismissed, absolutely nothing happens to the claimant. There's no penalty, nothing, even though years of everyone's time has been wasted. So I think this penalty is something which is really needed, because at the moment there's absolutely no deterrent to filing claims that are totally, I mean, completely abusive.
I completely understand your point. I think generally it is a valid point, but we have to be aware that law has its limits. So we have the right, one of the fundamental rights of access to the courts. So no law can forbid any person, however terrible they are, to file a claim. So what we can do is come up with as many tools, instruments as possible to make it deterrent for the claimants to do so. So I'm not sure if you're satisfied. I understand if you're not, but it is what it is.
I think what you're asking for is an anti-spam law in the anti-slap law. But anyway, Bea, I want to go back to those 1 billion forint, 2.5 million clams that company, that private company, spent of public funds. I guess part of it was public funds. Let me ask you this. There's a question here. How can this be avoided in the future? That a company like that can spend that kind of money on that effort? Will the SLAPS directive help practitioners like yourself keep up the pressure on misuse of public funds, even if such cases do not fall under the scope of the directive?
Just let me if my presentation was misunderstood. This 1 billion forint was spent on social media advertisements and not on litigation.
No, but social media.
Yeah, and this was just a background information about the company who sued the independent media outlet.
I guess to sort of contribute to that somewhat, I mean, we also depend on other pieces of legislation or other recommendations like the Aarhus Convention, for example, to be able to easily get access to information that allows us to move investigations forward. Mm-hmm. So these things sort of go hand in hand. With the directive and with the recommendation, we also need strong access to information laws, both on paper and I mean in practice. You know, governments have to actually have a culture of open access to information. So these things really go together.
Kind of leads me to a question of what you're saying is the sum of the parts. It's not, this isn't the silver bullet. This is among other efforts that have to be made so that people who are reporting or uncovering wrongdoing or whatever feel that they are protected, that there is not a growing sense of impunity that your mother faced, right?
Yes, that's right. I mean, it's all about the culture of governments, which change, thankfully. So if maybe currently there's a government which doesn't have this culture of transparency or this open attitude, then we are not going to be able to force that government, however much we try, to change their culture within a span of 5 years or however long they are in office through legislation. But with the next government that perhaps has a better attitude, we are going to be able to make steps forward. This is sort of my opinion after years of fighting against a lack of transparency. I mean, unfortunately, it's like that. Vanya said legislation has its limits. Changing the culture of an entire country, I believe, is one of the...
Bea, please.
Can I just raise one issue which we haven't touched yet, which is the ethical issues of media ethical regulations. And I think it's also important to talk about that not every litigation against journalists and media outlets counts as a slap. And I think we should keep repeating this, that you know, journalists can make mistakes, media outlets can make mistakes, and I'm working luckily I'm working in an environment where the journalists correct if they make mistakes. But I think this is the topic also what we need to discuss quite a lot. Just not to, not to talk, when we talk about slaps as a phenomenon, we should also talk about, how to differentiate between slap and not slap cases, because people have right to, to go to court if journalists and media outlets make mistakes.
Absolutely. Okay. Any other questions out there or online? Please do send them in. I have one here for Vanya. Regarding manifestly unfounded claims, you say many laws in Croatia would not be identified as such, right? Is there anything else that should feature in the directive's text in order to address this?
I'm not sure I understand the reasoning. So the reasoning for only manifestly unfounded claims to have the opportunity to be early dismissed, there is a legal reason to do so. So if you say, I'm not going to honor your right to access the court, you really have to have a really strong argument to be able to say that. In Croatia, the term manifestly unfounded is really a narrow term. I think everywhere it's interpreted very narrowly. In Croatia, my comment about Croatia was based on the fact that I have been now representing journalists and NGOs and publishers for 14 or 15 years, and our courts, even though in theory they have a possibility to say I am not deciding your case, or I am squashing your case because it's unfounded. And it can also be done in early stages of the procedure. That actually never happened, even though some of those cases were ridiculous. I'm not sure if I can find the better word. So everyone would, any lawyer or any media lawyer would probably agree with me. But it just doesn't happen in Croatia because the first instance courts want to go through with the whole proceedings, with all of the witnesses and everything, to avoid the higher courts from squashing their rulings. So I think it's also a matter of our judiciary, but I'm very confident that a very, very small number of cases, even if there are all prerequisites here, would end up early dismissed.
Pia, please.
I wanted to come back to Bea's remark how to differentiate between real cases which are slap and cases which are not slaps. And just to stress that there are indeed genuine cases of defamation. We're talking a lot about defamation because the majority of slaps are currently defamation cases, but the directive refers to any type of claim, because if we say it's okay, defamation, we close one loophole, then it will diversify to other types of cases. So indeed, in real cases, we need to maintain access to justice, and that's why the balance is, finding the right balance is so important. We cannot deny access to justice from real victims of defamation. For differentiation of cases, there are the indicators in the directive which are meant to help in that one, in the definitions. What are the indicators of abuse? And then just noting one factor which hasn't been mentioned so far is that slaps are also abuse of national justice systems. They are abuse of courts. They burden the courts with, which are already overburdened, they burden the courts with long-standing cases. So this means that also the member states actually have a strong interest in getting rid of such abusive cases.
Okay, I have a question for Matthew. The situation has worsened in a short amount of time. As you may know, the usual deadline for implementation is 2 years, and the legislative procedure between the European Parliament and the Council will still take some time. That goes for just about anything, doesn't it, here? In the meantime, what can be done? What is more urgent to carry out now?
I think the things that can be done now are legal support as well as training. But the legal support is really, really crucial. We have one project that we're running in Malta with media organizations that's happening thanks to support from UNESCO, where we've set up a legal clinic for media organizations that they can access anytime. The work that's done by the lawyers providing the support is completely free, and it's always available at any time, no matter what stage of publication the journalists are at. And so far, the feedback has been that this is extremely, extremely helpful. It's allowed news organizations to remove a hurdle to publication, where normally, even if there's a report that's about to be published that's in the public interest, because the journalists would have to consult a lawyer before publication, and that would incur a cost of, say, 500 or 1,000 euros, they would just sort of shelve the story because they can't afford those legal fees. But now that we're providing this kind of support for free, that sort of tax has been removed, that hurdle to publication has been removed. And this is something that we got started on last year. So we didn't have to wait for the directive, or we didn't have to wait for the recommendation. But of course, the financial support only came because this conversation had started. And thanks to the work that the Commission was doing, then UNESCO said, okay, this is something that we should also prioritize. Let's provide funding for this kind of work.
Yeah. Another question over here, please. Yes. Give your name and title first.
Yes, hello, good afternoon. My name is Vitor Teixeira. I'm a Senior Policy Officer at Transparency International EU. And I'm also here as member of the CASE Coalition Against Slaps in Europe. First of all, I would like to thank you for organizing this event. And I have to raise, it's not a question, but a concern that we had before, and listening to the panel, it emphasizes that concern, and that concern comes to personal scope. Listening to the panel today, it was talked a lot about journalists, which obviously we understand the reasons why that is so, but the personal scope of the proposal goes far beyond that. And our concern is that throughout the negotiations, this gets watered down for some reason, or it gets slightly forgotten. But our concern is not so much on this point, but perhaps on when we talk about the trainings that people will receive later when it comes to monitoring and so on, that the personal scope becomes narrower and narrower, and the concern is focused only on some of the targets of SLAP, which are journalists, but others should not be forgotten either.
Do you have a question? Just
no,
a statement there.
I wanted to raise the concern on personal scope.
But it's interesting that you point, I mean, yes, it's true, and we did mention at the very beginning, but we were focusing mainly on journalists, but we did mention that, yes, it's civil society, it's anybody who's trying to get true information out and to voice themselves. It's strange that interesting that you mentioned that, because I did a little bit of research ahead of time, and I saw a couple of headlines I thought were quite interesting about civil society groups. In Malaysia, a logging company filed a defamation suit against activists there. That case was thrown out. Honduran activists were put under house arrest for protesting a chicken company. That was thrown out. Environmental activists were sued over a New York Times ad that pointed a finger at coal about global warming. A Wyoming court threw that out. Those are cases that were successful in getting thrown out, but hopefully a directive like this is going to make it easier to do that in this country, in Europe, right?
So, I mean, even for our organization, I mean, for the foundation, which works mostly with journalists, any attempt to sort of define or to create categories of people who are protected is something that we will fight back really strongly against. Because even for modern news organizations, that is a definition that just doesn't work. When you have big investigations like the Panama Papers, Paradise Papers, you have all kinds of people working on it, people who are not journalists, people who are software engineers, for example, people who are statisticians, just researchers, fact checkers. They would not fit any sort of definition of a reporter or a very narrow definition of a journalist. They would not belong to a journalists' union, for example. So we don't want to have these classes of people, like one class that is protected and another that isn't. This is something that wouldn't even work for modern news operations. So it's something that we're really, really strongly against. I think Pia has something really important to say
Pia,
about
please.
this as well.
Yes, indeed, about the personal scope and the victims of SLAP, because the work started admittedly from the journalists, and later on human rights defenders were added to the narrative. But the more we proceeded with the work, we noticed that there are lots of other groups which are targets of SLAPs, and this also came up in the public consultations and in the stakeholder meeting, like I mentioned, that groups we didn't even initially realize, like these secondary targets, which are kind of targeted because the aim is to silence the primary target. Also those involved in preparatory and supportive activities, it's also now mentioned there. And for instance, in recital 7, we give an indicative list of human rights defenders, but it's an open list. So we, in the end, didn't want to close this, because the risk is that if we start defining journalists, human rights defenders, we actually limit the scope and deprive protection from those who actually merit the protection.
Okay, I think we're getting close to the end here. I think it would be nice to have a couple of final thoughts from each person. Let's do a lightning round. Bea?
I just wanted to join this part of the conversation that basically anyone, even in the social media, who is active and expressing his or her opinion about public matters could be a victim of SLAP. What is the core issue here is what the public matter is. And I think we have the answer to that. The European Court of Human Rights, in its case law, Article 10, right to freedom of expression. There are lots of case laws that covers this phenomenon. So I think judges and those who will apply SLAP directives will have good directions how to define public matters. And here again, I would really stress the need for training and on those basic fundamental rights which will be applied. So that's from my opinion, it's one of the crucial points.
Okay, can I shift over to Vanya? Some final thoughts? Sum up?
Okay, I'm going to say something that sounds maybe really general, but I think it's also very important, and I think there is a consensus here about this topic. So I think the general aim should be to broaden the scope of the directive as much as possible and to do anything to motivate as much as possible the member states to implement the recommendation, and if we can do that, I will be pretty satisfied.
All right. Pia, final thought or two.
Thank you, Chris. Just to note that legislation certainly has its limits, but it also helps to change the landscape and making things which were previously acceptable non-acceptable. So we should remember that one. And I think for this, the momentum is now there is a lot of spirit among the stakeholders in the European Parliament, but also among the member states to tackle this right now and to make this work.
Okay, finally, Matthew.
Because of my experiences, I tend to be a bit pessimistic. But this initiative is something that I'm really optimistic about, despite everything that's happened and, you know, despite the sort of terrible experiences and really extreme situations in countries where slaps are prevalent. I do think we can change it, because I mean, it's a practice which is extremely, extremely difficult to defend. And I think for any such practice, like corruption, like a lack of transparency, like inequality, you know, anyone who defends it is naturally on the losing side over the long term.
Great. Why don't we give a big hand to the panelists to start out with. Thank you very much to all of them. And as well to the interpreters, thank you so much for being a part of this and making it easier for a lot of people here. And Timo, let me pass that to you.
Then does this microphone work or not?
Oh.
Yes, okay.
It's working?
Yeah, okay, perfect. Good. Then I would like to thank you, Chris, for moderating today's panel. So thank you very much. And I would like to thank everyone for participating today, for raising questions, for giving very helpful comments. Matthew, I hope that we in the European Parliament, together with the Council and the Commission, can prove that you don't need to be pessimistic, but optimistic about the outcome about this piece of legislation. When I started working on that, and now being officially named the rapporteur for this, I feel that this is really touching the core of the European principles. This is not about journalists, this is not about activists, and this is not about NGOs. In the core, this is about democracy. If we silence those who criticize the powerful, if we silence those who criticize lawmakers, then we will really harm and destroy democracy, because democracy is only as strong as criticism is, because otherwise no one would scrutinize the lawmakers and powerful individuals. And SLAP cases are indeed misusing court systems which are set up to defend the weakest in society. So abusing courts for the powerful is something which is not only unethical, and thank you very much, Bea, for also raising the question about ethics today. This is something which we all have to see as an attack against us, against our democracy, against the rule of law. And I hope that we can defend it with this piece of legislation. We learned today it's not perfect yet, and it will maybe not be the only tool to overcome the problem of silencing criticism, but it is an important one. So I hope that we in the European Parliament will be very helpful for journalists, for activists, to defend your rights and to defend democracy. And with this, I would like to thank you all again for being here in the European Parliament, in a real room, discussing finally again in person very important matters. And my promise is that this will not be the last possibility to exchange, and also promise you that we will work very hard in the European Parliament to take the proposal by the European Commission, try to make it even a bit better, and in the end have a law which protects everyone who is scrutinizing the powerful. Thank you very much and take care.